unabashed,
the most unpredictable,
becomes a headline,
the most volatile,
outrageous behavior,
unsubstantiated narratives, a battle of personalities.
Welcome to Grant Tamasha, a co-production of the Carnegie Endowment for International Peace and the Hindustan Times. I'm your host, Milan. Justice Dhananjaya Yeshwant Chandrachud was the 50th Chief Justice of India. An alumnus of Harvard Law School, he served as Additional Solicitor General of India, and he was appointed as a judge of the Bombay High Court in 2000, becoming the Chief Justice of the Allahabad High Court in 2013. In 2016, he was elevated to the Supreme Court of India, where he served as Chief Justice from November 2022 to November 2024. Justice Chandrachud is the author of a new compilation of speeches titled Why the Constitution Matters. In this new book, he reflects on his quarter century of experience as a judge, illustrating how the Constitution impacts everyday life and why it remains a cornerstone of democracy. To talk more about the book and the state of the court in India today, I'm pleased to welcome him to the podcast for the very first time. Sir, congratulations on the book, and thank you so much for taking the time.
Thank you very much, Milan. It's a pleasure to be here.
I want to start by asking you about the place of the judiciary and the Supreme Court more specifically in the kind of current democratic context in India. I think as most of our listeners will know, since 2014, the Indian party system has been completely transformed. After a prolonged quarter century of coalition politics, there is once more a dominant political party around which the political system revolves. Now, as the BJP's dominance has grown, there have been some analysts who have argued that referee institutions like the court meant to provide a kind of check on executive power to ensure a level playing field. Some of these institutions have become subordinate or unduly deferential to a powerful executive which seeks to concentrate power. So my question to you, if you could kind of step back and reflect at a kind of macro level, is how do you see the place of the Supreme Court in today's political environment?
Milan, for one thing, this is not the first time that we have had a single-party government. Of course, now we have a coalition after the last elections were held, but it's not the first time that we had a single-party government in 2014. We've had one party dominating the political space in New Delhi, in the union government, previously as well. But you're right in saying that this has happened after a quarter of a century. Now, insofar as the judiciary is concerned, I believe that the parameters for the exercise of judicial review are pretty much stable and well settled. Which is first that as a court within a democratic system governed by a written constitution, our courts do follow basic principles of separation of powers, which we are mandated to follow. The separation of powers is regarded as part of the basic features of the constitution. And the second, that courts do differ to the executive on issues of policy, be it economic policy or social policy. Because in any democratic society, particularly in a parliamentary form of government, the fact that a law has been enacted by elected representatives of the people gives rise to a presumption of constitutionality. Now, that presumption of constitutionality can certainly be displaced by satisfying the burden of establishing that the law has infringed constitutional safeguards. So the basic principles on which judicial review is exercised have remained constant even before 2014. And I think that's important to highlight, in the course of our conversation today. Because if we regard the role of judges and the parameters which they have to apply as having evolved to a state of near equilibrium, the role of the court in that sense is well defined in the polity, irrespective of the nature of or the extent of political power which is wielded by the government in the union in Delhi. The second thing which I'd like to emphasize is that, yes, though you have had after 2014 a strong political force in parliament in terms of the electoral majority which the government controls, India, in that sense, doesn't exist merely in the union, but in the states as well. And I believe that is a very powerful decentralizing force even today in the polity. You have governments which are not governments of the political party in the center in states like West Bengal or Tamil Nadu, Kerala, for a while in Karnataka as well, and some of the other states which I needn't give you the whole list of them. That's the other thing. So there's always this balancing factor in the polity. The third thing which I'd like to mention is really this, that despite the fact that the lines for the exercise of judicial review are fairly well settled, what really happens is this, that as you have one party assuming a character of dominance in, say, parliament or in the union government, there's a perception that that political spaces may have shrunk to that extent in elected institutions like parliament. And a lot of times you do find that the dilution of the political space in parliament and in other democratic institutions gives rise to a lot of litigation which then takes place in the court, in the sense that the court then becomes a sort of a substitute for the deficiencies of democratic political space in other institutions of the nation. Now, that poses a real problem for the courts, because at the end of it, courts are duty-bound to apply fundamental principles of the separation of powers, that ultimately it's for Parliament to decide what legislation to bring and what's good for the country. Of course, the courts are duty-bound to apply yardsticks on the constitutional validity of a law, or in fashioning policy, simple issues of policy on, the nature of foreign trade or the extent of taxation, both in financial matters, economic policies, to what extent, for instance, should you have foreign investment in a particular critical area of the nation. I'm just giving you a couple of instances of, policy determinations. So courts still have to continue to apply these principles, irrespective of whether the political space is shrinking or otherwise. But then there's always this expectation that because the political space for dialogue may have shrunk elsewhere, courts must step up and provide for those deficiencies in the political space. For one, I have a little bit of a doctrinal issue with that, because I think the role of the court in that sense at a constitutional level must be constant, irrespective of who or to what extent political power is wielded by the government at the center. Yes, there is a perception, and Milan, you're right on that. There is a perception, and there's a lot of academic writing on this as well, in which it has been said that, the authority which the Supreme Court exercised has varied in inverse proportion to the extent of political power which has been wielded by the government at the center. So that when you had coalition governments, you found that the Supreme Court really exercising a far greater remit in the exercise of the power of judicial review. Contrary-wise, when you have a very strong government at the center, you find that the Supreme Court, in that sense, is confining itself to traditional boxes for the exercise of power.
So let me just push you there for a second, because there have been many critics and people who write about the court who have said that in a number of cases, the court has exhibited what they call undue deference to the executive. Essentially, for fear of contravening a very popular executive, they've chosen not to take the government on head-to-head.
I'm not sure that's really whether that's more anecdotal as opposed to being reflective of the actual position, because you would find that in at times, I'll give you an example. In 1971, Mrs. Gandhi came back to power on the platform of Garibi Hatao, which was basically get rid of poverty. And she had a a huge mandate in the elections after 1971. And in 1973, you get the basic structure judgment, which imposed limitations on the power of Parliament to amend the Constitution. Now, the 1973 judgment, which produced a huge backlash for the judiciary because we had the first supersessions of senior judges of the Supreme Court in the appointment of the Chief Justice of India, that judgment came when Mrs. Gandhi was at the zenith of her power. Of course, thereafter, you have the emergency, which is declared in 1975, and then you have the judgment which upheld the suspension of the right to move a court for habeas corpus. So, the evidence may point in both directions. Likewise, if you look at the judgments after 2014, you will find that in certain areas, courts have been deferential to the government, where I feel that there is an element of justification because, if courts start entrenching upon issues of economic policy, particularly, and other aspects of social policy which merge with economic policy, where unless there is a violation of a constitutional right, a fundamental right, a part of the Bill of Rights, I think the courts will be getting into the political arena, and it's important for the courts also to keep off the political arena to maintain their own sense of credibility and legitimacy in the democratic space as well.
So let me just kind of pause on that note and ask you about a particularly, I think, difficult time in the history of relations between the executive and the Supreme Court. In 2018, 4 of your colleagues on the court addressed this impromptu press conference. One of the claims they made was that the executive was attempting to interfere in the court's business and that the then Chief Justice at the time was using his prerogative as the so-called master of the roster, which is the power to assign cases to benches, in a way that was, say, friendly to the government. Now, we don't need to kind of relitigate everything that was said at that conference, but in your opinion, what was the impact of this event? And did it lead to procedural or other changes in terms of how the executive and judicial branches interacted?
Speaking for myself, I have reservations about 4 judges of the Supreme Court going to the press and, giving vent to their anguish as they felt about the then Chief Justice of India. In any collegial institution, particularly in the judiciary, if you have a grievance about, what is being done by the Chief Justice of India, you have a collegial environment. You walk across to the Chief Justice, you talk to other colleagues. If you feel that, the voice of those who are anguished may not be adequate enough, as opposed to, going public to the press, because there's so much that you have said and you haven't said. And ultimately, then the Chief Justice gets into a very difficult situation to respond to it in public. Really, in that sense, breaches the line of restraint which the Chief Justice, as the head of the administration, has to follow. But that apart, that was not your question. On the impact which this has had, I can really identify clear-cut impacts of that press conference, or maybe just the way, India is evolving. I'm not sure whether this was a direct impact of that press conference, or, obviously courts are responsive to what's being said in the press, in the media, on how people are perceiving the work of the court. And one of the things which happened was that, the roster, the master of the roster is the ability of the Chief Justice to assign cases by subject to individual judges, just to sort of give the audience an idea of what the master of the roster power is. Unlike, say, the American Supreme Court, which sits en banc, all 9 judges hearing every case unless a particular judge has recused. In India, we have 34 judges of the Supreme Court. On an average, there are about 70,000 cases which come up before the court, which are filed every year, which makes it impossible for all the 34 judges to take up every case. So we typically sit in benches of 2 judges for every case. The Chief Justice could be sitting in benches of 3. The important constitutional cases go to benches of 5, 7, 9, or upwards, depending on which is the case which is being reconsidered. So typically, if you are reconsidering a judgment of 5 judges, then the bench should consist at least of 7 judges. The judgment in the privacy case on whether privacy is a fundamental right came up before 9 judges, because there was an earlier judgment of 7 judges which said that privacy is not a fundamental right, and that was being considered. So you always sit in a larger combination when you are reconsidering an earlier judgment. So one of the consequences I feel which emerged in the last few years is that when the roster is prepared by the Chief Justice, that is now being published and it is being put out on the website of the Supreme Court. The roster essentially assigns cases by subject matter to individual judges. So, for instance, just to give you an example, we would have public interest litigation, which is moved by individual citizens who claim that there is a violation of a constitutional right, which they share in common with others. It's not private to the citizen. Or you may have tax litigation. Tax litigation, again, could be direct tax and indirect tax. We have something called service litigation, which basically relates to employment disputes of people who are employed in government or semi-governmental bodies. The largest inflow of cases into the Supreme Court is under the head of criminal cases and civil cases. So almost every judge of the Supreme Court deals with criminal cases. That may include bail, it could include appeals, it could include a whole lot of other things like preventive detention, so on and so forth. So the Chief Justice prepares the roster based on 2 principles. How much is the inflow in that jurisdiction? If the inflow is, say, about 15,000 cases a year in that jurisdiction as criminal cases, obviously you need a large number of judges to hear those cases. If the inflow is, say, 3,000 cases, as in cases under the Consumer Protection Act or the competition law or electricity laws, you need fewer judges. The second thing which weighs with the Chief Justice is the specialization of individual judges. Because after the Indian economy opened up with the market reforms in 1991, a large amount of legislation by Parliament governing these specialized areas, which were earlier the domain exclusively of government. A clear example is the generation, transmission and distribution of electricity, which was entirely in state hands until the reforms took place. Now, with the area having opened up, you have specialized tribunals, which are dealing with electricity disputes. You have specialized tribunals dealing with disputes in areas like securities law, airports economic regulatory authority, for instance, which, because the airports, and you now have greenfield airports which are being run by private investors, and they're coming up all over the country. So both these aspects are borne in mind. So the putting out of the roster and making it known to the public, I think, has been a very important step, so that it's not that the Chief Justice, assigns a case at random to individual judges. Within the roster, Milan, if suppose 5 judges or 5 benches of 2 judges each is hearing that particular subject matter, then typically cases are assigned by the computer on a random basis. Of course, there are exceptions to that where there's a recusal by a judge. To tell you something on a lighter vein, I was asked, and I tried to do it. In the High Courts, for instance, when the roster is prepared, you actually say in the roster, the Chief Justice will say that if bench 1 has a recusal, the case will go to bench 2. If bench 2, there is a recusal, it will go to bench 7. Now, this seems to be very transparent because it obviates the exercise of the Chief Justice's power. But this led to a different sort of abuse. If bench 2 is regarded by the lawyer as a little more liberal than bench 1, they already know in advance that if bench 1 recuses, they'll go to bench 2. So there's then an attempt at bench hunting. So that's something which I was told when I became Chief Justice of the Allahabad High Court, that this might not actually serve the ends of transparency. The other, apart from, of course, publicizing the roster, a lot of other changes have taken place in the court since then. A lot of these changes are based on technology. In fact, when I became Chief Justice of India, using technology to make our processes more transparent and more open was part of my mission. So to give you just a few examples, one of the things that we did was that, we now have live streaming of cases. So every case in the Supreme Court is live streamed. That was also a product of COVID when, the court couldn't have shut down. And we had to have open court hearings. So people had to connect online. The lawyers were all over the country. They had left Delhi, or even if they were in Delhi, they were in their homes. So live streaming has been an important source of opening up the court proceedings to a greater degree of scrutiny. And I think the greater degree of scrutiny, whether it's by individual citizens, whether it's by the press, by social media, by television channels, it's promoted this degree of accountability in the work, not just to the Supreme Court, but the high courts as well. The administrative work of the Chief Justice of India goes on for about 4 to 5 hours every evening after court. So the Chief Justice of India is like any other judge. He is first, or she is first and foremost, a judge. You're doing judicial work just like all other colleagues are doing, except that the CJI will also preside over a bench of 2 or 3 judges. But after the day's judicial work is over at 4 or 4:15, and very often, my court will go on till 5 o'clock, on an average, you put in about 4 or 5 hours of administrative work, which will involve projects, allocation of finance, appointments to the judiciary, even ceremonial visits by people who want to come and see you. So one person has to be entrusted with this responsibility. I take the criticism that, wherever an individual is vested with responsibility, the choices which that individual makes, particularly in urgent situations, might be up for scrutiny. And in the age of social media, everything that is done goes to be scrutinized by social media, where sometimes people are well informed, at other times they're not well informed. And, you become the source of endless trolling and, social media speculation. But that, I guess, is just a product of the times in which we live.
Hey, Grant Tamasha listeners. Thanks for listening to the podcast. Putting this show together each week is a labor of love, but it takes a lot of work to put out a great show every week. If you'd like to support the work we do at Grant Tamasha, please visit ceip.org/donate. Don't forget to subscribe to us on Apple Podcasts, Google Podcasts, Spotify, or on your favorite podcasting platform, so you'll be the first to know when a new episode rolls out. Let me just kind of pick up on this point. I was going to get to it later, but this is a nice segue, which is that, there have been experts out there who have said the administrative burden on judges at all levels is just way too high, and that it is high time that India carve out the administrative functions of courts and of tribunals and have these be managed by a separate professional agency which has kind of administrative expertise. They're armed with kind of modern management practices and technologies. Other countries have done this. If you take the United Kingdom, they have something called Her Majesty's Courts and Tribunal Services, HMCTS. They essentially take a lot of the kind of back office functions of the courts and perform those separately with the objective of freeing up judges' time to be judges, right? In the U.S., my own country, you have something called the Administrative Office of the U.S. Courts, which again does a lot of that central support for the federal judicial branch. Is it time, do you think, that India should consider that kind of a reform, which would allow judges to essentially do what they've been trained and probably really want to do, which is, listen to cases, write judgments, deal with bail, deal with pending appeals, and so on and so forth?
I completely agree with that line of opinion or reasoning. A lot of time, particularly of the Chief Justices in the High Courts, and I'm not just talking about the Supreme Court, but the High Courts as well, a lot of time of the judges in the High Court and their Chief Justices is spent on committee work in the evening. For instance, they have the infrastructure committee where they are supervising, the infrastructural work of constructing new court buildings across the state. And this is extraordinarily complex because you have large states in India. You have other committees like the finance committee. You have the purchase committee. And you have the building committee for your own court. And I've sat in those committees, and I know how much time is spent in doing that kind of work. And I think we need to think of some innovative solutions For instance, one way out would be to have an umbrella infrastructure corporation, either for the whole of India or at least for, unlike the American situation where you have a separate federal judiciary,
right.
You have a separate state judiciary. In India, we have one unified judiciary, right from the Supreme Court down to our district courts. Of course, the control over the district judiciary essentially vests with the high courts. So it's federal, but with this distinction that the high courts exercise the ultimate control. The Supreme Court has no administrative control over the high courts or over the district judiciaries. Now, I think it's time for us to perhaps look at alternative solutions to reduce the burden on the non-judicial burden, should I say, on our judges. Now, having said that, India is, in a sense, very complex, and I'm not putting forth these complexities to say that we wouldn't be able to do it, but that we need to have these kind of complexities, borne in mind when we factor in solutions or think through these ideas. Now, one of the problems is that the states, not the problem, but that's part of the identity of our states. The states are extremely zealous of protecting their own turf. And this is not just those states which belong to a political party which is not the political party at the center. Even states which are governed by political parties which are the same as the political center, are very zealous about protecting their own rights as state governments. So you have to get the states on board. The second, and this is something which is anecdotal, which I'd like to share. Over the last 5 years before I retired, I was chairing the E-Committee of the Supreme Court. Now, the E-Committee of the Supreme Court is the chief technology arm. And, the success of the E-Courts project has been spoken about not just in India, but all over the world. This is a joint project which is funded, of course, by the government of India, and which is handled primarily by a judge of the Supreme Court in conjunction with other experts, domain experts. I mean, you have a lot of domain experts which come and do the work. We have introduced, artificial intelligence, and I was working in very close coordination with a young startup which was headed by Dr. Anshul Pandey, who came in from New York. And, his team spent, Milan, about a year just understanding the Indian judicial system. And when they actually devised a pilot project, he said that, look, we have worked across the board on different institutions, including public institutions, but we haven't found anything as nearly as complex as the processes of the Indian judiciary. And that kind of affects the kind of back-end systems which you have to develop in the areas of technology. Now, because we had a homegrown project on technology, we basically deployed an open source platform. If we had given it, to maybe a proprietary platform, it would have cost us many times the amount of, the kind of budget that we eventually were able to deploy. So, the thing is that, the Indian judiciary also, though it's one federal judiciary, there are differences from state to state. So, the same application in one state may be called by a different nomenclature in another state. So we found a solution for that. The states were very zealous of the fact that, the nomenclature we give to a particular application in each state shouldn't be altered in the name of uniformity for deploying technology. So the answer we found was, all right, we'll not tinker with the names which you give your applications in each state, because these are customs and traditions and conventions which have grown over the last 150 years. But we said at the back end of the system, we'll have a unified nomenclature. So there'll be a corresponding back-end nomenclature which will, be unified for the purpose of technology. But the front end will reflect, what you are all used to calling it in terms of terminology. So these are some kind of, practical problems which we encounter. The last point which I want to make is that we have experimented with having court managers for managing the court system. Now, though we still have court managers, the experience generally has been that court managers have not been as successful as they should have been. Now, what is the reason for that? I think one reason for that is that a lot of the administrative work in the Supreme Court, in the High Courts, and in the district courts is done by judicial officers, the judges themselves. Now, when the court managers came in, their role was not really defined. The court managers felt that, they were not given a free run by the judges. The judges felt that the court managers didn't have enough knowledge about the system. And another problem was this levels of attrition, because you recruit a court manager, but unless you provide for a whole chain of promotion, or a chain where they will go from one occupation to another over a period of, say, 10 years, typically we would find that in a year or two, these court managers would just leave the system because they didn't have any prospects of career advancement.
Upward mobility
for the and this problem, this conflict between the judicial officers, particularly in the district courts, who felt that the court managers knew nothing about the system. They had an MBA, but having an MBA, it doesn't make for a good court manager. You have to have an intrinsic knowledge about the court system, which they don't have. So what's the answer to it? I think one of the answers to it would be to begin from the drawing board, to have or to curate courses in court management. Sort of maybe we can have some of our premier management institutions, the IIMs, the Indian Institute of Management, or even the other tier 2 schools, to devise courses in court management, because court management is very different from, say, managing an IT services company. Courts do a lot of what other companies do. You're also purveying data, so you're doing the work of an IT company. You're also dealing with finances, so you're dealing with like the Ministry of Finance, so on and so forth. But I think we need to have well-trained people who will come into the court system, aware of the practical realities of the court system, and then we'll have to allow judges also to give up a lot of this administrative burden which they carry. For instance, in our district judiciary, so much time of the average district judge is taken every day in a roll call of cases. So if the court has, say, 150 cases listed, the court will first go through the roll call of cases to see in which case have the summons been served, where's the summons not served. So the judge is doing such absolutely irrelevant work, which leaves very little time at the end of the day for core judicial functions. So I think a combination of things and more professionalization, greater professionalization of the administration is necessary. That coupled with the provision of finance, because finance is the key. For instance, for technology, I found that there was never a dearth of finance from the government of India, because, our mission to incorporate more technology into the system, say for the digitization of records, the use of artificial intelligence, it dovetailed into the government's overall Digital India mission. So I didn't have a problem with finance there. But on infrastructure, there are states and states. There are some states which are very good with finance. Other states which are terrible with finance. They don't want to fund the judiciary at all. Even if finance is made available by the government of India to the state for the judiciary, that is never allocated in practice to the High Court to spend. So, you have different levels of commitment to the judiciary on the part of the states in India, because that's the complexity again of the nation. But your point basically of the need to professionalize administration of the courts, you're absolutely right.
So I want to come back to the administration of justice, but let's come to some substantive issues here. I want to ask you about something that is kind of near and dear to my heart. It's something that I've worked on, which is this quest over many decades to ensure that India has a quote unquote cleaner brand of politics. I think many of our listeners will know Indian politics has long been plagued by two serious maladies. There's been a proliferation of money in politics and a surfeit of politicians under the criminal scanner. There was a landmark judgment in 2003 in which the Supreme Court made it mandatory for candidates seeking higher office to submit, at the time of their nomination, judicial affidavits which disclose their criminal antecedents, their financial assets and liabilities, and their educational qualifications. About 10 years later, in 2014, the court ruled that if a sitting member of parliament or member of the legislative assembly in the states was convicted and there was not a stay on that conviction, he or she would be disqualified immediately. Now, more recently, there have been people appearing before the court through PILs asking the court to disqualify political candidates who stand accused of heinous crimes, subject to some safeguards. The court has not been willing yet to go in that direction. And I wonder if you could shed some light on what the complexity of that particular issue is, right? I think a lot of people look at India, including many Indians, and say, the data suggests that, as many as 4 in 10 members of parliament have a criminal case against them. 3 in 10 have a serious criminal case, which means if a conviction were obtained, they would do serious jail time. Now, of course, these are cases which have not been proven, but where there's a prima facie case being made. How does the court decide where to draw the line here in terms of its own intervention?
One of the fundamental principles of criminal jurisprudence, which we have followed in India, and perhaps that's because of our common law tradition and the importance of liberty in the Constitution, is the presumption of innocence, that an individual is presumed to be innocent unless that individual is proven guilty at the end of a criminal trial. Now, what that really means is that there is a certain degree of reluctance on the part of the court to impose disqualifications merely based on an accusation of crime. The reason for that is that if the court were to create a disqualification, that would give rise to 2 problems. The first problem is that the court would be legislating, or that's the question which judges would ask themselves. Would this court be legislating by imposing a disqualification, which Parliament has not imposed while enacting the Representation of the People Act, which is the union law which governs the field? The second is that if you impose a disqualification merely on the basis of an accusation, would that be somewhat in breach of the presumption of innocence? Now, there is a problem, obviously, over here because, using the presumption of innocence or, the fact that the court is legislating to keep your hands off doesn't do anything to deal with the problem on the ground, which is the number of legislators who are accused of crime, and in some cases of very serious crime. And, we have contemporary statistics on that. I know that there was a case in 2018 where I was a part of the Constitution bench. And I think that judgment of the Constitution bench in that sense reflects this concern of the court, which is that how far can the judges go in this area in doing essentially what would amount to a legislative exercise? Do you leave it to Parliament or do you leave it to a legislative body? Now, the point of the matter is that would the legislative body do that in the first place?
Right. If it's against their own interests,
exactly.
Basically.
The 2003 decision which spoke about, the need for disclosure was much, much easier because disclosure in that sense is only putting out information. So in the 2018 judgment also, The court said that, political parties who give election tickets should be mandated to provide some disclosure on their websites. So that's again an effort of the court to sort of draw the lines that we can go thus far. Does the court really have, it would be very desirable, but does the court really have that mandate in a constitution, to in that sense either mandate that the legislature enact law, or in the absence of that, to do that itself?
But do you think, there are some proposals have been made, organizations like ADR have said this, there have been private member bills introduced in Parliament saying that there could be safeguards such that it's not just based on an FIR, it's based on a judge having framed charges. So if it's applied a judicial mind, it is a heinous charge, right? Which means something specific in the Indian context. Say you would if a conviction were obtained, it'd mean a 5-year jail sentence or more. And these are charges that would be, or cases that would have proceeded at least 12 months before an election, right? So they're not just put on the eve of the election. Would those kinds of safeguards allay fears about this idea of, because what you're saying essentially is, in an effort to protect the rule of law, you as the court don't want to be seen as violating the rule of law, right? Which is the presumption of innocence. Would these safeguards allay some of those concerns?
I would agree with you to a certain extent that, if we were to think of, safeguards in terms of the stage, not just a mere accusation, but where charges have been framed. Because charges are typically framed after investigation is complete and after the court which is framing the charges has had an opportunity to apply their mind, at least prima facie, to the evidence which is available on the record, that there is a charge which has to be answered by the accused. So that could be one aspect, namely the stage at which, this would kick in. And the second, the seriousness of the offense. Somebody, for instance, accused of rape, a murder. I'm just giving you two examples. There could be other examples of the seriousness of the crime. Should be dealt with very differently from a property dispute between two neighbors, right? So that could be the seriousness of the crime. Then, the time element. The time element between, say, the next election, the next general election, which is due, and the stage at which the disqualification is sought to kick in. But at the end of it, there are instances in our jurisprudential history where courts have stepped in the absence of, or in the absence of a legislative mandate, or in the presence of a legislative vacuum. The classical case was, sexual harassment at the workplace, where, in the absence of a law which was enacted by Parliament, the court applied, the Convention on the Elimination of Discrimination Against Women, CEDAW, and said, until Parliament enacts the law, we will lay down guidelines. So the court...
a similar thing happened recently in a case revolving the appointment of election commissioners, right? Which says, pursuant to Parliament passing its own law, we believe that there should be a committee made up of the Prime Minister, the Leader of the Opposition, and the Chief Justice of India to appoint new election commissioners. Now, Parliament later wrote its own version of that law, which changed the composition, but there was an interim step which was taken by the court.
Yes, absolutely. There are illustrations where this has happened in the past. But I think, there's also the some element of disquiet, perhaps, about the fact that, can the criminal justice process be misused in a given case? And if that is happening, should the courts, in that sense, impose a mandate of their own in terms of the law? I think our judges and our courts have adopted a more conservative approach of not imposing legislative parameters by judicial diktat, and of then following it up with general directions to expedite cases against elected members of Parliament or the state legislatures. That's an area where I think, courts have felt themselves far more within the remit of their traditional function. for instance, there was a judgment of the Supreme Court and a whole series of orders applying the writ of continuing mandamus, just for people who are not really lawyers. Typically, the writ of mandamus is applied as a one-time direction by the court to direct or mandate that a public authority fulfill a duty under the law. Our courts have also applied the continuing mandamus, which is that after we lay down law, we follow up the implementation of our judgment to its logical conclusion. So, in this case that I adverted to a moment ago, the court imposed directions that each of the states must create special courts for the trial of offences which are registered and where charges have been framed against legislators. And the high courts should be monitoring the conclusion of those trials on an expeditious basis. Perhaps I think the court felt it far safer for it to be able to do so, because ultimately an expeditious trial, in the sense, is in the interests of the accused. The accused can't say, I don't want an expeditious trial. And society has democracy has a very vital interest in ensuring that these trials take place expeditiously. On creating, norms which are more in the nature of a legislative norm. I mean, my gut feeling as a judge is I can understand why courts are a little more reluctant to do that, And that is, in fact, a limitation of democracy in that sense, if you look at it that way, because courts feel that they have a certain role and they shouldn't be transgressing the line which divides legislation from adjudication.
So I want to ask you about another aspect of cleansing politics, namely political finance. Specifically, I want to ask you about the issue of electoral bonds. This was a new modality of political giving in which both the donor and the recipient would remain anonymous. It was legislated in 2018. In a landmark 2024 judgment, the court ruled that these bonds were unconstitutional. Now, when the matter was first brought before the court, I think it was ahead of the 2019 general election, the court said, look, this is a weighty issue. We don't have much time before the poll. We need to not rush into anything. But it took the court almost 6 years to issue a ruling, in which time, many people say that this gave a huge advantage to the ruling party. Now, even though in the judgment of kind of many pro-democracy, good government groups, the court eventually ruled the correct way, saying that these were unconstitutional, they did believe that by moving so slowly, the court essentially kind of nullified some of the effects of its eventual ruling, right? And it kind of echoes that famous phrase that justice delayed is the same as justice denied. How would you respond to some of the critics' claims?
On the impact of the judgment, I believe that though the judgment came in 2024, whereas the electoral bond scheme had been legislated upon 5 years before, the impact of the judgment has been very, very significant for two reasons. First, we struck down the electoral bond scheme as unconstitutional. So the court made it clear that there would be no recourse to the electoral bond scheme as a process of electoral funding, namely of anonymous donors and anonymous recipients, because we said that this would be legitimizing, in that sense, political corruption. And that was one thing. The second, we asked for a disclosure of those who had contributed to political parties and where the money had gone. After the judgment, we got applications by the bank which was running the implementation of the scheme, saying that this will take us very long and there are all kinds of administrative difficulties. And we said, nothing doing. We're giving you a short window. We want this disclosure. And the fact that this disclosure went public itself.
Yeah, well, I should just say, magically, it happened very quickly, yes. Despite the administrative excuses. It happened, within a matter of days.
And that allowed for researchers, political parties, journalists to look into the data which was put up in the public realm. draw inferences to put it out before the Indian polity. So both in terms of the striking down of the electoral bond scheme and the disclosure of data, I think it has had a tremendous impact. Now, there's no gainsaying the fact that ideally the judgment could have come much earlier. Because, as you said, there's always this delay, and in the meantime, monies have been collected. Now, the third thing that the court did was, of course, to say that the income tax exemption which was available for contributions would not be available. We also said that, this meant the electoral bond scheme also envisaged that where a donation was made by a corporate body, there was no cap on how much of your profits you could contribute. You could be a company which is not making any profits at all, and yet you would be contributing. Or you may be a loss-making company and yet you'd be contributing. So we said this showed the arbitrariness of the whole exercise. We struck down the income tax exemptions. So it's had a big impact. Ideally, of course, I take the point that, this judgment, if it had been delivered, say, 4 years earlier, would have obviated the contributions which were made in the meantime, in those 4 years. But what happens is that because, of Article 145(3), which the court felt was applicable in the facts of this case, namely that the case raised an important constitutional issue and had to be referred to a constitution bench. A constitution bench is a bench of at least 5 judges. Now, I quite understand why my predecessors found that difficulty in constituting the bench of 5 for 5 judges. 2018 is when the law comes in. Then you have 2020 February, of course, COVID. I'm not justifying it. But these are the practical realities. 2020 February, COVID came in. Then you had, the whole impact of COVID. And then, of course, the reference which was made in 2023, perhaps, to a constitution bench. And we took it up in 5 months after the reference was made. This is, Milan, a real problem which any Chief Justice faces, which is that when you set apart 5 judges or 7 judges to hear an important constitutional case, undoubtedly it's extraordinarily important for the polity that these cases should be disposed of early. But then I know, because it's impacted my mind, and I know how many of my predecessors have also thought about it. The moment you have 5 judges who are taken off hearing regular civil and criminal cases, somebody's bail application, somebody's civil suit, somebody's pension, you're taking away those judges from hearing the cases which also affect the lives of private citizens. It's a very difficult choice for a Chief Justice to make. And how many constitution benches can you really have? Not more than probably 1. If you run 2 constitution benches at any given point of time, you have 10 judges out of 34 who are doing only constitutional work, except for Monday and Friday. So while I take the point which you have made that, these kind of cases should be decided early, it's equally a very difficult administrative choice for the leader of the institution to make,
But I think there's a perception out there amongst the public that, oftentimes there seems to be this kind of dual track justice, right? So there was a case in which a famous television anchor who was arrested got swift granting of Supreme Court bail, whereas you had habeas corpus petitions from Jammu and Kashmir in the wake of Article 370, which languished for many months, if not years. And so would you agree that there is a broader trust problem the court has to address, because the average man or woman on the street is saying, okay, this important case, which cuts to the heart of an important issue, whether it's Babri Masjid, whether it's 370, it seems to be taking a very long time. Whereas all of a sudden in the middle of the night, there's a convening because someone needs a bail application. That person's high profile. Is there a tension there?
I'll tell you, Milan, there is this perception, which is really a selective perception, which is generated by one segment of the social media, may not really be reflective of reality. Now, you're referring, of course, to the grant of bail to a very prominent television personality, which was taken up quickly and it was dealt with. Let me give you another example where the same level of alacrity was applied by the Supreme Court. There was the case of Teesta Setalvad, she was granted bail by the Supreme Court until the High Court decided the case. In the High Court, she was directed to surrender immediately, which meant that she had no time even to move the Supreme Court. The matter was assigned to a two-judge bench in the Supreme Court. The two judges differed, which meant that she would have been taken into custody the same night. The Chief Justice of India felt that it was a moral duty of the leader of the institution to ensure that a hearing is granted to the person. Whether the person should be protected or not in terms of liberty is for the judges. The Chief Justice never bothered about what the ultimate outcome is, because that's the authority of the court.
Prerogative of the justices.
Prerogative of the court. Immediately the court constituted a three-judge bench, and the three-judge bench protected her personal liberty. We had a case of a very prominent opposition leader who was about to be arrested at an airport, in the Northeast. A mention was made to the Chief Justice in the afternoon saying that, he's going to be arrested just as he was about to board an aircraft. The court took up the matter immediately and heard the matter and protected his personal liberty. So, very often you find that, while, the social media will highlight, one particular case on why someone was granted bail or someone was not granted bail, you would have cases falling on the same side of the spectrum of the grant of protection to personal liberty. Now, in a given case, you may have a critical view of a court not granting bail to an individual. That's, again, a criticism which every citizen in exercise of their right to free speech is entitled to voice. I'll just give you one last example. In the largest state in India, there was a decision there was a decision of the High Court to close down all the madrasas. The madrasas are, the institutions which impart education, not only religious education, but secular education as well to Muslim students. And there was a direction to close down the madrasas, as a result of which close to, I think about 15 or 20 lakh, please forgive me if my figures are wrong, 15 or 20 lakh students across the state would have been ousted from the madrasas. The teachers would have been rendered jobless. When the case came up before the Supreme Court, there was an immediate stay of the judgment of the High Court, which ensured that these students were not displaced, the teachers didn't lose their livelihood, and eventually the Supreme Court delivered judgment, protecting this right and saying that, look, the High Court had no business to go into this issue because the law on which they relied was only a law for recognition, and it was not really a law which empowered anybody, least of all the High Court, to close down the madrasas. So a large number of such examples which you will find where, despite, that's what we began with, despite, what is perceived to be a very strong government in the center, courts have been alive to their duties, as some of these examples which I have given. And these are examples where the court has acted with alacrity. Now, in such a huge volume of litigation, as I said, there's always this problem for the Chief Justice. When I was the Chief Justice, one of the problems which I faced was even the Constitution Bench cases. There were some cases which were pending from 1990. Do I not take up those cases? You always have this great moral question before you. Do I only sort of prioritize the more recent cases because they're the more live cases? And do I ignore the older cases? There's no real answer which would, in that sense, be ideal, given the imperfections of any human institution, particularly an institution which is such huge burdens of litigation coming into the court.
So, Justice Chandrachud, you've been very generous with your time. Let me maybe bring this conversation to an end by asking you to kind of reflect a little bit on the future. Having served on the court for so long, having served as Chief Justice for a full 2 years, which, many of our listeners will know is not always the case given the way that Chief Justices are appointed. Oftentimes they might have quite a short tenure, but you had quite a lengthy one. As you reflect on this collective experience, you were actively engaged in the public debate. You're a regular writer, contributor, thinker on these issues. What are some of the issues that you want to spend your own time thinking about, writing about as you go forward, right? I mean, we've talked about many of the infirmities of the justice system. We haven't even gotten beyond the courts to talk about policing or prosecutorial bodies or corrections or lawmaker. I mean, there's a whole litany of things in the supply chain of justice, as you call it in your book. What are some of the things that you want to dedicate your own intellectual time going forward in terms of things that you think are really pressing for courts and justices and the kind of legal fraternity to think about going forward?
For one thing, I think there are critical areas of reform in the Indian legal system and the Indian judicial system which are necessary. Because just as India is, making rapid strides in terms of economic growth, I think the existence of the rule of law is a very critical element in the overall growth story. And I do believe that, we need fundamental reforms in the Indian legal system, in the Indian judicial system, in terms of our procedures, in terms of the extent of adversarial litigation which takes place in the court, and to ensure that the crucial time of the court, the quality time of the court is spent genuinely on cases which need the attention of the court. So these reforms within the system, I think, are key to the future. And, having come from that system, I couldn't have really spoken about the reform so long as I was in office, because you're constrained, you're restrained by, the needs of institutional discipline. You have to apply the law as it stands, and you have to try and work your way within the system. But now going forward, I think, it's time that we have a broader national debate on the need for reform on all fronts in the Indian judiciary. Second, I think we need to spend some more time on modernizing the Indian judiciary, both in terms of better knowledge management, better technology adoption within the Indian judiciary, which would be key because every area of our social and economic life is now moving towards a more technology-enabled life globally. And I think the Indian judiciary cannot be left behind in that quest. And the third, which I think is equally critical, is for promoting greater diversity in the judiciary. And that diversity you can have not just by saying, we want to have more women judges in the system now, but looking at where we draw, our personnel from, in terms of making the legal education, which has already become more diverse, but the legal profession becoming more broad-based, more accommodative of, diverse segments of our society. So I think, just responding to your question, these are the three areas I think where I'd love to really contribute, write, speak, and engage.
My guest on the show this week is Justice Dhananjaya Chandrachud. He's served as the 50th Chief Justice of India. He's also the author of a new compilation of speeches titled Why the Constitution Matters. Justice Chandrachud, thank you so much for taking the time. It was a real pleasure to speak with you today.
Thank you very much, Milan. It's really been a pleasure and honor to converse with you.
Grantamasha is a co-production of the Carnegie Endowment for International Peace and the Hindustan Times. This podcast is an HT Smartcast original and is available on htsmartcast.com. You can also find us on Apple Podcasts, Spotify, or wherever you get your podcasts. Don't forget to rate and review. It helps others find the show more easily. For more information about the show, to support the work we do on Grantamasha, and to find the writing we mentioned on this week's episode, visit our website, grantamasha.com. Tim Martin is our audio engineer. Mira Verghese is our executive producer. Additional assistance is provided by Annabelle Richter. Thanks for listening, and see you next week.
This was a Hindustan Times production brought to you by HT Smartcast.
HT Smartcast.